various constitutional institutions that affects the determination of these wages and salaries. We have also understood how these wages and salaries are also affected by various external factors. So continuing with that, today we are going to discuss the various legal aspects of these wages and salaries. Legal aspects means how these wages and salaries are understood in terms of various enactments, the various acts which have been enacted by the Constitution of India or with the influence of the directive principles of state policy, how they have influenced the term these wages and salaries. And beyond that, we'll also see the six such broad category of wages which you need to understand, which sets up the fundamentals of these wages and salaries. So just to start with, as I was telling you that we classify all these wages into six such broad categories, and these six broad categories are like bare subsistence wage, the top of need-based minimum wage, statutory minimum wage, fair wage, and living wage. We are going to discuss all of these wages in one by one. So to start with, one of the fundamental concepts of these wages, which actually have been defined, way back in the 18th century, the emergence of uh, Adam Smith, who proposed the concept of subsistence theory, like propounded by David Ricardo. And as per the provisions of the subsistence theory, no, you must pay that much to the workers, whereby the workers will be able to perpetuate their race without any increase or decrease. In a sense, that whatever is necessity for the workers for their subsistence to maintain their livelihood must pay that much to the workers. So whenever we do talk of this bare subsistence wage, actually the lowest amount of wage which will enable the workers to fulfill their physical needs, physiological needs, right? Whenever we talk of the bare essential needs. And sometimes we also see that uh, the number of earning members per family are less than the number of dependents. So whenever we talk of this bare subsistence wage, actually the wage which should be sufficient enough for a worker working in any organization to fulfill his bare physical needs and the needs of his or her family in respect to the capacity of the industry to pay is called as this bare subsistence wage. So we understand that this is the lowest level of wage which will enable the workers to fulfill their bare essentials only along with the family. Of course, with the growth of the concept of these wages and salaries, now the concept have gone beyond from this bare to living wages. We will discuss that. But the industries to which these workers do belong to must ensure that the workers are paid more than that of the bare subsistence living. Beyond this, the next level of wage, if we to talk of, is somehow an improved version of that bare subsistence level, where we to talk of need-based minimum wage. And this need-based minimum wage, the concept was actually developed in the 15th ILC, 1957 itself. And as per the discussions, as per the recommendations, the amount of the amount that should be paid to the workers, which can really fulfill his bare essentials of life, is called as the need-based minimum wage. Now, in a sense, if you see that I told you that the bare essentials of life here: food, cloth, and shelter, roti, kapda, makan. So the amount of money which we must pay to the workers should satisfy his bare requirements of food, cloth, and housing requirements. So in this regard, Dr. Ackroyd, he defined that a full-grown adult per day to maintain his health and efficiency. To maintain his efficiency. So that is the way we calculate the minimum food requirement which will be able to provide that 2700 kilocalories of energy to a full grown adult is or should be taken as the calculation of this bare wages. Of course, after that, certain ratifications were there. Now, later on, when based on the demands of the uh, industrial manual working class, so this 2,700 calories were further ratified to 2,400 calories or 2,200 calories, depending on the nature of work itself. But the original concept is that a full-grown adult requires 2,700. Industrial workers, of course, they do put a lot of physical work. So industrial workers, they do need 2,700 kilocalories of energy per day. Similarly, when we talk of the clothing requirements of these industrial workers, it has been defined that the clothing requirements should confine to 18 yards per annum. 18 yards per annum, of course, these clothing requirements have been extended to four such consumption units where per annum 72 yards per family of the workers is what that has been defined. And in case of housing requirements, the amount is calculated on the basis of any such government's industrial housing scheme, the minimum amount that should be given to the workers to fulfill their housing requirements. So based on these three concepts, the amount of wage which can the amount which can really fulfill 2700 kilocalories, 72 yards, no, and housing requirements. Now, beyond that, as I was telling you, that in India, mostly you'll see that the number of earning members are less, and so many family members do depend on the earning members. That is the reason why, whenever we do calculate this need based minimum wage, that should be calculated on three such consumption units, two adults and one child. And of course, all these requirements are defined for a child also. Like we do talk of 2,700 calories of energy is required for a full grown adult. The same time, 1,400, like 1,400 calories of energy is required for a child. So like that only it is calculated. But always this minimum wage is calculated on the basis of three such consumption units per family. And of late, one more thing has been added. Say the requirement of this fuel, lighting, or any other like miscellaneous items, if at all it is required, that should constitute the 20% of the total minimum wage and should be added to define the need-based minimum wage. So after calculating the fooding requirements, clothing requirements, and housing requirements, we add 20% of that as a fuel or lighting or any other miscellaneous requirements of the worker. Then we do define the need-based minimum wage. And it is calculated in terms of three such consumption unit. So when we do talk of the bare subsistence wage, that is the lowest level of wage what should be given to the workers just to subsist. But when we do talk of this need-based minimum wage, need-based minimum wage is a wage which actually should be given to the worker to fulfill his bare essentials along with the family's necessities. Now, beyond that, we will talk of this statutory minimum wage. Actually, the statutory minimum wage is defined as per the statute, means as per the Minimum Wages Act 1948. The statutory minimum wage defines the amount of wage beyond which or less than that where the efficiency of the worker will be affected or is likely to be affected. So what we should pay to the worker to maintain and to preserve his health and efficiency along with the bare essentials of life is defined in terms of the minimum wage, statutory minimum wage. So whenever we do talk of maintenance of health and efficiency, we say the minimum educational requirements and the minimum medical requirements are to be given to the workers. So along with that need-based minimum wage, whenever we do add these medical facilities or educational facilities, that will add to the minimum wage. And this statutory minimum wage also defines the basic rate of wages that should be given to the workers, and certain allowances, normally we call it as DNS allowance, which should allow the worker to cope with the variations in the cost of living index, we call it that. So the with the increase of this cost of living index, or with inflation itself, when the price of the commodities do increase, to cope with that increase in the price of the commodities, this DNS allowance is provided to the workers for that. And similarly, at times you will also see that certain other basic amenities, facilities, or certain other essential commodities are also supplied to the workers at a very concessional rate to enable the workers to have their livelihood. So in that case, the cash value of all those concessions in respect of supply of those essential commodities are also to be included for the calculation of the minimum wages. So the Minimum Wages Act, which like as a concurrent act, of course, the central government or the respective state governments do notify, or as per the provisions of the Minimum Wages Act, it has to be revised within a period of 5 years, or as and when it is required, appropriate government feel it fit, can be revised. But it includes the parameters such as the basic rate, the cost of living and allowances. Sometimes it will also include certain other allowances, specific allowances, if at all it is required, and the cash value of the concessions given to the workers in for the supply of these essential commodities also. The next category of wage, what we call it as a minimum wage. Now, the statutory minimum wage and the minimum wage are often used interchangeably. The meaning remains almost same, where we do say that it provides all the basic amenities, basic requirements of the workers, along with the medical requirements, the educational requirements, and the basic amenities. The only difference is that the minimum wage is not only defined in terms of the statute or through the Minimum Wages Act only. Sometimes these wages are also defined through a bipartite negotiation that takes place between this workers representative and the management representative in the organizations. So in a process, it will say that sometimes these wages are also defined through the process of collective bargaining. And collective bargaining, we understand that is a process of settlement of the terms and conditions of employment, terms and conditions of service. So wages are also a part of these collective bargaining processes. So sometimes wages are also determined at the industrial level, which of course may not go less than that of the statutory minimum wage as defined by the government. That's the minimum level of wage that each and every worker should be facilitated with. Each and every organization should pay to the workers. Now, any organization which pays for any reason less than that of the minimum wage can also be liable for certain legal punishments, legal actions. So, minimum wage and this need-based minimum wage are the concepts which are used interchangeably, but almost the meaning remains same. We do come out with certain other concepts of these wages, where we do talk of these fair wages. Now, the concept has been developed way back in the year 1930s, where the Royal Commission on Labor was appointed, and the committee was appointed to deal with these fair wages. Of course, the concept was, based on the Gandhiji's principle of trusteeship, where Gandhiji come out with the opinion that these workers should treat themselves as the co-owners, and the entrepreneurs should treat themselves as the co-partners. So the profit that the organization do earn is because of the productivity of the workers, productivity of the laborers. So if the organizations do earn more and more profit, why the organization should not distribute these profits with the workers. So based on that only, this committee on fair wages have studied the concept and come out with four such important factors that should be considered for the determination of these wages. The first such factor is called as a productivity of the laborers. Of course, the organization's profit is completely based on the productivity of the laborers. So, more the productivity, more the profit, that should be reflected in terms of an increase in the wages and salaries of the workers. So, productivity can be taken as directly proportional to the level of wages that the workers will get from the organization, right? Similarly, prevailing wage rates, what the neighboring industries are paying, of course, similar sort of industries, similar sort of places, localities, because wages depends on the cost of living index and wages also depends on the industry type. So what the similar sort of industries in the similar location they are paying, if I do pay less than that, now the organization is going to face a problem in terms of labor turnover. So workers, there will be migration of the workers from one organization to other. The organizations which do pay more, normally these workers will move in that line only. So that is the reason before finalizing these wages and salaries, you need to go for a wage survey where one of the important aspect is that what is the prevailing wage rates of the similar sort of occupation, similar sort of jobs in similar organizations and a similar type of industry in the same locality. That has to be taken into consideration because the fundamental principles, if you remember in the first section, we discussed that the compensation administration is based on the concept of equity and fairness, where equity can be individual level of equity or can be internal level of equity or can be external equity also. So unless and until we ensure that there is external equity and this prevailing wage rates are to be considered, so there will be labor turnover. We need to talk of that. Similarly, the level of national income and its distribution. So, in a sense, we do say the per capita income of a particular country is what that should be taken into consideration for determination of these wages and salaries. So, based on your GDP, GNP, and the way it is distributed, the national income is distributed among the employees. That should be a base of determining the wages and salaries of the workers. And beyond that, also these wages and salaries depends on the place of the industry in the economy of the country. Now, sometimes to promote this industrial activities, government comes out with different sort of facilities, different sort of schemes whereby these industrial workers do get additional benefits, additional facilities which normally these workers are liable to get, and that is the reason why depending on the cost of living index of a particular locality or a particular place in the economy, depending on the basic industrial activities, basic economic activities which are being carried out in that particular industrial zone or that particular economic zone, the wages and salaries are to be paid to the workers. So sometimes we do say that for the salaried employees, we come out with certain allowances like city compensatory allowances, CCA we call it as city compensatory allowance. So that is provided to the workers because they need to cope with the cost of living index of different cities. Different cities may have different sort of cost of living index. So how these workers will cope up with that? That's the only reason. So whenever we do say that the workers should not be paid at the minimum level if the productivity of the workers are more and the organization is making more and more earning out of the productivity. So why not the organizations will share this profit with the workers? That's the basic concept of this fair wages, where we say that these wages are dependent on the first factor is productivity of labor, second factor is this prevailing wage rates of the neighboring industries, third is the level of national income and distribution, and fourth is the place of the industry in the economy. So normally, whenever we do talk of these fair wages, it is more than that of the minimum wages that are to be ensured to the workers. But interestingly, whenever we do talk of the wages, we come out with one more concept, that is the living wage. Actually, all of these enactments related to these wages, which have been influenced by the directive principles of the state policy of our constitution. So, Article 43 of this Indian Constitution's directive principles of state policy, it says that it has instructed all the states to ensure that all the workers, may it be agriculture or industrial or any kind of workers, a living wage is the conditions of work, the conditions of work for a decent standard life and full enjoyment, entertainment, leisure and social cultural opportunities. So in a sense, if you do understand the basic requirements of the human beings, as the human beings are living in a civilized society, civilized community, so fulfilling those requirements should be the living wages of living wages that the workers will get. So, in a sense, we can say that living wages are the wages which includes the satisfaction of the bare essentials of life, right? As if we have understood the need-based requirements of the people. This living wage should also ensure that the health, education standards of the workers are also preserved, the efficiency of the workers are also maintained. Beyond that, whenever we do live in a society, we do have certain obligations towards our society. So the amount that the worker, the minimum amount that the worker requires to fulfill his social obligations can also be included over here. Beyond that, the frugal comforts of life, that is the minimum level of frugal comforts of life, what is estimated by this current human standards. So those are the things that we need to take into consideration for determination of the living wages. And again, as I said, as per the directive principles, as per the constitution, all the organizations should pay to their workers at the living wage, at the rate which can fulfill all of these things. Okay. So, in a sense, if we'll have a comparison of all of these processes, right, all of these concepts, right, we say that the bare subsistence wage is the lowest level of wage, of course, but nowadays none of these organizations are advised to pay the workers at the bare subsistence level. Now, it is said that the organizations which cannot pay their workers at the minimum level should not exist also. So beyond this bare subsistence level, we do talk of this need-based minimum wages, fulfilling all these bare physical requirements of the people, and the same time taking care of the family, taking care of their fuel, lighting expenditures, or any other facilities which are the essential requirements of the present day. We will talk of minimum wages. Normally, this minimum wage and statutory minimum wage are taken together, right? So, minimum wage is another one, the lowest level of wage, which will ensure that the workers' efficiency, health and efficiency are achieved. So, here you need to talk of the minimum level of wage as defined by the respective state governments or the appropriate government itself from time to time, and organizations are bound to pay at the level of the minimum wage, cannot pay less than that, otherwise it will call them for certain legal punishable actions also. We're talking of fair wages. Now, if the productivity of the workers are defined in terms of or productivity of the workers lead to the profitability of the organization, so organizations must also share their profit with the workers, so workers should be paid beyond the level of minimum wage or need-based minimum wage. So fair wage says it is a you can say the kind of payment that should be in between the minimum wage to the living wage. The highest level of wage that these workers are ensured at the place of work is the living wage, which include all the factors like satisfying their bare essentials, preserving their health and efficiency, or we to talk of basically fulfilling the requirements of their civilized society or obligations towards their civilized society, and also the frugal comforts as per the current needs of the human resources, current standards of the human resources. So these are the four such factors which are to be ensured through this living wages. So this is the highest level of wage. We said that the need-based minimum wage is the lowest level of wage that should be ensured to the workers. However, statutes say that minimum wage is what that should be ensured, and living wage is what that should be ensured to the workers. This is the highest level of wage we talk of. Now, if we'll see the concept of these wages and salaries as interpreted by government itself, right? Uh, Here you can see that from time to time during our 5-year planning periods, some or other focus is also been given to the definition of these wages and salaries, and the way these wages and salaries are to be fixed for the industrial workers that are to be taken into consideration. So the focus of the first to seventh planning period, the entire focus was on the establishment of tripartite wage boards. Tripartite wage board says these wages are to be defined, or wages are to be fixed in consultation with the unions, the workers' representatives, the employers' representative, and the government as a regulatory authority. So a tripartite wage board is a wage board which is appointed by the appropriate government in consultation with the employers and the workers, or employers representatives and workers representatives, their unions, you can say, the union members, right? And they do carry out all the detailed activities to fix and revise the minimum level of wages. Right? So their focus was on equal pay for equal work and working conditions, etc. And here you can see, as of now, 17 such wage boards have been appointed by the appropriate government. But nowadays, only one, we to say, working journalists wage board is only one that is functioning. Otherwise, all other wage boards have lost their relevance in due course of time. But during the 8th and 9th planning period, say the thrust was shifted in terms of the productivity of the labor, so whatever we call it as. So the thrust has shifted to the capacity of industry to pay on the basis of the productivity and the profitability. So the concept of profit sharing, the concept of ownership among the workers are what that were being focused during this 8th and 9th planning period. So what was thrusted upon was this profit sharing. Thrusted upon was the concept of participation in the decision making process relevant to these wages and salaries. So profit sharing is what that was being thrusted. But okay, this was a focus that we have understood from the perspective of the government. Now, one more thing that we need to understand is that how these wages are actually being interpreted by various such enactments that we do have for these wages. So let us see that how these wages are actually defined by various laws, enactments, right? And how these wages are being interpreted by various enactments. And we will discuss. Let us go through the concepts first. Then towards the end, we'll discuss what are the things that we need to take into consideration for the improvement of the situation. Now, Section 2(6) of this Payment of Wages Act, as you can see, wages are defined as the remuneration. The concept of remuneration was given by Elton Mayo, right? That 14 principles, you can see. Remuneration is that anything that the workers do receive because of their work, or anything that the workers do receive for the contribution they are making towards the organization is called as a remuneration. So, any kind of remuneration that the workers should receive, which will include, the base salary, any kind of allowances like the dearness allowance, or maybe house rent allowance, or transportation allowance, medical allowance, health allowance, food allowance, whatever it may be, or all those kind of allowances. It will also include the overtime work if at all the worker carries out certain overtime duties. It includes all the payments that the workers do receive because of the holidays also. We say that's a fringe benefit. We discussed it earlier also. If you remember, fringe benefits are the benefits which the workers do receive beyond their wages and salaries. So payment for time not worked is a category. So all those holidays will come under that category. So whatever that the workers do receive, the payment that the workers do receive during these holidays or during these leave periods will also be included in the wages. We to talk of if any kind of dispute related to these wages are in the process of adjudication, in the process of no, it's a decision in the court. So if the court has come out with any such award which is beneficial for the workers, so that should also be taken as a part of the wage. So under any award, under any decision of the honorable court, right? Maybe you are aware of the fact that whenever we to talk of this wages and salaries or any other matter, right? So to deal with any such problems of the industrial workers, we have labor courts, industrial tribunals, national tribunals, right? So if at all it is there, now beyond that we do have high courts and supreme courts. But in any of these courts where the decision is being in favor of the workers will also be a part of these wages. And beyond that, we need to talk of any other such facility that the workers do get because of the termination of their employment. Say, for example, we do talk of this gratuity benefits. We do talk of other insurance benefits. If the workers are under EPF, so pension benefits. So all of those should also be taken as a part of the basic benefits, whatever that the workers do get. Right? But we need to understand one thing, that remuneration that the workers do receive because of their employment and in terms of money. And to understand in a simpler language, in that way, that any kind of benefit that the workers do receive because of their employment, because they satisfy the terms and conditions of employment, and that amount of money is always expressed in terms of certain cash values, monetary values, we do see, right? So that is how this section 626 of this Payment of Wages Act 1935 defined these wages. If we to talk of the Minimum Wages Act 1948, section 2H, it says that quite similar to that of the definition given by the Payment of Wages Act. It says that all the remuneration expressed in terms of monetary value. So the condition is there. Expressed in terms of monetary value payable to a person employed in respect of his employment. So this is common, that remuneration received by the employee. First. Second, this remuneration should also be expressed in terms of monetary values. And third, that the workers do receive this because of the employment terms and conditions, because they satisfy the terms and conditions of employment. That is the reason why these workers do get their remuneration. Right? So on the satisfaction of these three conditions, we said that whatever the workers do get is part of the wages. But Minimum Wages Act also takes these house rent allowances into consideration. Right? So remuneration that is expressed in terms of certain monetary value and is administered because of the terms and conditions of employment. House rent allowances are also included in the definition of wage under this Minimum Wages Act 1948. If we to talk of the Payment of Bonus Act 1965, sorry, there is a typo was here, 65, section 21, right? Where also the salary or the wage is defined as the remuneration. But here you need to understand one thing, that the term remuneration excludes the overtime work. The term remuneration excludes the overtime work. Right? And the terms of employment is satisfied. It is expressed in terms of monetary value, and the allowances which are to be provided to cope with the cost of living index, that is the dearness allowance, that will be included in the definition of these wages and salaries. So excluding this overtime work, rest of the things are there, but dearness allowance is included over here. Like under this Minimum Wages Act, we have also understood that house rent allowances are also included. Here, dearness allowances are also included. So actually, the interpretations are different whenever we do come out with the definition of these wages under different enactments. We'll see that. Section 2S of this Payment of Gratuity Act, it says that all emoluments earned by the employee on duty or on leave. So any kind of remuneration or the benefits, it includes benefits also. Any kind of remuneration or the benefits that the worker do receive because he is on duty, he is been present there in the organization on his job, or maybe he is on leave, or he receives all those benefits during holidays also, right? But rest of the things are same, like it has to be expressed in terms of certain monetary values, and it is being paid to the workers because they do satisfy the terms and conditions of employment. So satisfying this, we will come out with a basic definition of these wages, and what this, as per the Payment of Gratuity Act, dearness allowance is what that is included there in the wages, but any kind of bonus or the commission that the workers are liable to get, and maybe or may not be, but a part of the profit sharing process, are not included. Similarly, house rent allowances, overtime wages, or any other allowances are also not included for the calculation of these wages and salaries. So you see, different enactments actually are coming out with different sort of interpretations of the things. We need to talk of the ESI, Employee State Insurance Act, Section 222, where it says that remuneration paid in form of cash, okay, remuneration term is there. Cash means in terms of, expressed in terms of money, right? And because of the terms and conditions of the employment, the contract of employment is fulfilled, right? But will include all authorized leaves, all legal strikes or lockouts or layoffs, retrenchments, any kind of thing which has got its legal entity should also be taken as a part of the wages, or the calculation of these wages, legal payments, we to say. Now, sometimes this absurd strikes, like illegal strikes, will not be included over here, because during the time of illegal strikes, workers may not get their wages and salaries, right? So, ESI Act has got a different like implementation of the said definition, right? Like all the period of authorized leave, lockouts, strikes, layoffs, retrenchments, all these legal processes where the worker is liable to get certain payment will also be included over here. Similarly, under this concept of social security, we do have this Maternity Benefit Act, right? And Maternity Benefit Act, Section 2N, what it says that remuneration is to be paid or payable to the woman, right? When they satisfy the terms and conditions of employment, first condition, and that is expressed in terms of certain cash benefits, right? But what these wages should include all the forms of allowances what are being paid to those female workers, lady workers, right? So that will include all of those allowances, cash allowances. We to talk of incentive bonus, right? Any kind of pay for performance related scheme, if at all is implemented over there, then incentive bonus is there for that. We to talk of the money value of any such concessional item which is supplied to that particular person, to that particular female employee, will also be a part of the wages. So concessional value in terms of supply of essential goods, it may be in case of supply of certain food grains or any other article, if at all it is defined by the appropriate government, can also be taken into consideration, right? And the cash value should also be a part of the wages that we need to take into consideration, right? Certain other acts, like to talk of this EPF, Employees Provident Fund and Miscellaneous Provisions Act 1952, Section 2B, what it says, basic wage. Actually, the provident funds are basic wages, so they have come out with the concept of basic wage. But it says all emoluments, right? Like all such kind of facilities or gas value, whatever they do earn, right? While on duty or on leave with wages in accordance to the terms and conditions of employment and in cash. So whether the workers are on leave or they are on duty, but the amount has to be included there in the definition of his wages. Right? Quite similar to that of ESI Act. Here you can see, right? And common things are, as I said, remuneration, terms and conditions of employment, and is expressed in terms of monetary values. We will talk of Section 2Z, Equal Remuneration Act, 1975. So we do talk of this Equal Remuneration Act because uh, as per the provisions of the directive principles also, so that fairness has to be administered by the organizations, where we say that this remuneration will include the wage and salary, right, or any other additional emoluments, like the cash benefits or benefits payable in terms of cash or kind, whether the in respect of employment, of course, it is there. But we need to talk of all those benefits which are in the form of kind to be converted to certain cash values of that, right? So everything has to be expressed in terms of the cash values to be taken into consideration, right? Certain other acts, we do say, like this Workmen's Compensation Act, it says that wages are defined as any kind of privileges or benefits being estimated in terms of money, and is there because of the uh, employment relationships. We understand that. Section 2RR of Industrial Dispute Act 1947, wages and remunerations are expressed in terms of money because of terms and conditions of employment, and includes DNS allowance, value of any house accommodation, house rent allowance, or if at all a kind of benefit of housing is given to the worker, house accommodation, any kind of traveling concession, if at all, is given to the worker. So all of those, the cash values of all of those allowances can also be a part of the wages. Now, we have understood actually many such enactments, and these enactments has different sort of uh, implementation of the said things. However, when we to talk of all of these enactments, the enactments excludes few such factors from the wages, from the consideration of wages. Like any kind of bonus, if at all, is given to the worker, which is there because of the profit sharing scheme, is not being considered as a part of the wages. Right? But sometimes we have understood it from earlier definitions. Sometimes this performance bonus, incentive bonus, right, attendance bonus are kind of things which have been taken as a part of the wages in certain acts. We'll see that. Right? Similarly, the value of any house accommodation, the supply of essential commodities like light, water, medical facilities, or any other basic amenities. So that is also excluded from the consideration of these wages. Contribution made by the employer to any kind of social insurance scheme, contributory scheme, yeah, or any kind of contribution made by the employer for social assistance, right, should not be a part of the wages and salaries. So we say that like the contribution made by the employer towards this pension scheme or towards the provident funds, towards the insurances, to be excluded from the calculation of these wages and salaries. We say that any kind of traveling allowances or any kind of or like it may so happen that the cash value of any such traveling concessions, if at all, is being given to the workers, right, should be excluded from the consideration of these wages itself. And if I had to talk of any kind of amount which has been paid by the worker himself to defray these special expenses, right? So if the worker has been involved in carrying out certain other special expenditures which are reimbursed to the workers, will also not be considered as a part of the wages. It should be a different quote altogether. And similarly, gratuity or any kind of you can say, separation benefits. Gratuity is a like thing which is given to the workers when they get separated from the place of work. So like gratuity, if any other benefit is there by the organization, by the or by any kind of statute, what the workers are liable to get should not also be taken as a part of these wages and salaries. So these are the factors which actually are excluded from considering a part of the wages and salaries, but still we need to think of certain factors what are still a dilemma for us. No, we have understood it when we have analyzed the definitions as it is given, like by various enactments, and has been revised from time to time, has got different interpretations. Yeah. Some of the definitions, they include these allowances. Some of the definitions where we have seen that dearness allowance is included, somewhere dearness allowance is excluded. Certain other enactments included house rents. Certain other enactments exclude house rent allowances. Certain other enactments include all those kind of allowances being given to the workers or in cash value of that, but others have excluded that. Right? So, whether these allowances are to be considered as a part of the wages or salaries or not, that's still a question. No. What to do? Where the worker is entitled to receive that benefit, but can we extend that benefit as a part of the wages and salaries? It's still in a dilemma. Still, there's a dilemma, no? That's what we need to talk of, right? We're talking of any kind of incentive, which is, of course, related to the performance performance based pay systems or performance based incentive system. Sometimes we call it as production bonus. Of course, that is given to the entire department as a whole, entire floor as a whole, right? We do talk of attendance bonus. Now, whether this should be treated as a part of the wages or not, we have understood that some of the definitions they have included this, some of the definitions they have excluded that. Right? Bonus as a part of the profit sharing scheme have been excluded. So that is a different thing. But what about this pay for performance bonus? What about these incentives as a part of the pay for performance? What about this production bonus or attendance bonus or any other kind of bonus which is directly related with the productivity of the worker at the place of work? Right? So whether that should be a part of the wages or not is still a dilemma. We to talk of any kind of commissions, incentives payable to the employee. Nowadays, you have to see that most of the jobs are linked to the productivity, right? Where the base package is fixed, but the variable pay packages, what it includes, this commissions or incentives, are enlarged, enhanced, we can say, right? So whenever we talk of these commissions or incentives, it also being administered on a monthly basis. But should it be a part of the definition of wages or not? We have understood some of the enactments. These commissions or incentives are excluded, and in certain other enactments, these commissions are included, incentives are included. So what actually it should be done? You need to think of that. We do talk of this overtime earnings, right? Or any kind of deductions on the account of fine, if at all it is there, right? So whether it should be included or should be excluded. Now the person has worked, may it be overtime, but he has worked in the organization. But you'll see that some of the definitions that we have witnessed, they have excluded this overtime and others have included it because that's the earning of the particular person. So what actually it should be done? Similarly, in case of any kind of fines or maybe the contribution towards certain funds, when we deduct certain amount from the wages of the employees, like anything, you cannot deduct it from the wages unless and until it is authorized by section 8 to 13 of the Payment of Wages Act, or unless and until it is authorized by the agreement between these employers and the employees, workers. So you cannot deduct anything. But even if you are going for certain legal deductions, right? Like maybe deductions towards insurances, maybe deductions towards income label, or deductions, what do you call it, as TDS, right? So all of those things, should that be a part of the wages? And how do we define wages, including these or excluding them? So these are the dilemmas that we do have. And beyond that also, you'll see that even if this aspects related to these wages and salaries are under concurrent list, where the respective state governments and the central governments can be the rule making authority. So most of the state governments, respective state governments, they do come out with their own way of defining this compensation and administration practices, even if it has been defined by the appropriate government from time to time. Right? So that is the reason why we do see that there are certain disparities in terms of the legal implementation of the terms. Challenge is how to overcome that. Whenever I do come out with certain disparities in terms of the definition itself, implementation will be difficult for me. No? So that is the reason why the central government of India, like in the year 2019, they have come out with the wage codes with an objective of maintaining uniformity throughout the country. So it should not happen that the respective state governments or the central government, whatever the wage policies they do have, that should differ significantly. So we need to understand that there should be a uniformity in terms of the practices. And that is the reason why in the year 2019, the central government of India, they have come out with wage codes to be applicable uniformly throughout the country. And what it includes, as per this wage code 2019, wages includes all remunerations. We have understood that, right? So remunerations will include the basic wages or salaries and any kind of allowances, if at all it is there. So that has to be included there in the definition of wages, right? And it is expressed in terms of monetary value, and there is an employment contract. So these are the things common. But what it has included is a basic pay and dearness allowance and any other allowances that is being administered by the organization for the retention of the employees. Right? So these additional allowances are actually now leading towards the retention of the employees on a long run. That's what we need to understand. So your basic pay, DA plus any other allowances should be a part of the wage, right? So includes remuneration, right? Workers do receive what they receive, basic pay, DA, and any other retention allowances. And that is being given to the worker in terms of cash value, in terms of their employment, right? And to standardize that, this wage codes also standardize the legal processes, legal aspects, which should not be included in defining these wages and salaries. So, like any kind of house accommodations, if at all it is being like provided to the worker, any kind of supply of lights, water, or medical assistance. So as to say, these are the things which adds or extramural things which are being provided to the workers, right? So this should not be the cash value of this house accommodation or supply of light, water, medical attendance should not be considered as a part of the wages. Similarly, if the employer is contributing any amount towards any social insurance scheme, may it be provident funds, may it be the Employee State Insurance Act, right? So that should not also be taken as a part of the wages. We are thinking of any kind of conveyance allowance, traveling allowance, if at all, is being produced, maybe on actual basis or on a reimbursement basis, whatever it may be, but that should not be a part of the wages, right? Any kind of payment that is made by the employer to the employee to defray certain special expenses, right? That is also not treated to be the part of the wages, right? We say that house rental allowances, overtime allowances, wage codes have defined that these are not to be taken as a part of the wages. These are additional benefits, supplementary benefits, which are to be given to the workers, right? Commissions payable to the employees. Any kind of commissions, right? Performance based pay system, whenever we are talking about. So, any kind of commissions that the workers do receive should not be a part of the wages. So we say similarly, any kind of retirement benefits, gratuity or pensions, whatever it may be, whatever the workers do receive in case of discharge of their duties, should not also be a part of the wages. We say retrenchment benefits, any kind of gratuity, ex gratia, or any other retirement benefits should not be a part of the wages. Right? So even if we do have these enactments, right, defining these wages in different terms altogether, but we need to understand that the time has come to streamline the practices, right, in a similar way. So we understand that the contributions of these wage codes 2019 to a large extent will be able to do that, but still implementation of the said things are to be prioritized by respective organizations. So we have come to the end of the second session, second day, and in the second session only these two units are only there, unit 5 and unit 6. Like, we have understood the basic legal concepts and the legal entities affecting these wages and salaries. So let us stop over here. Once again, we'll meet for the next session, right? Third session we'll have it, right? And we'll discuss the other aspects of the compensation and reward practices. So thank you very much and have a great day.